welcome. If you joined us for part one of this series on January 9th, we are super happy to have you back. But if you missed it, you can always watch it on YouTube anytime, and we will drop in the link in the chat so you can click on that and find part one of this webinar series. But today's webinar is going to be 1 hour, and you may earn 1 hour of New York CLE credit if you watch the webinar and also submit the CLE form, which we will link to at the end of the webinar. I'm going to read out a code during the webinar, so please write that down. You're going to need it when you fill out your CLE form. And we won't be dropping it into the chat, so just listen for it. You can see the materials for this webinar on our website, and we'll also drop a link in for that. And use the Q&A feature, please, at the bottom right of your screen to drop in any substantive questions you have. You can drop them in anytime. We're going to be keeping track of that. And you can also upvote other people's questions. And we're going to prioritize the questions that get the most upvotes for our presenters. And alternatively, please use the chat function on the bottom left of your screen. There you can say hello, say where you're from. You can also ask any administrative questions that you might have for the Grunin team, who I want to introduce right now. Stephanie Spartz is here and Yona Kim. They're part of the Grunin team, so we'll answer anything you have along the way. But before we get started with Deborah and David, I just want to let you know that we're really looking forward to hopefully seeing as many of you as possible at our upcoming conference on June 4th and 5th. Called Legal Issues in Social Entrepreneurship and Impact Investing in the US and Beyond. It's going to be held at NYU Law. If you haven't registered, please do. There's still time. We'll drop a link. Again, if you have any questions, drop them in the chat. And I am going to hand it off to Deborah and David.
Hi there, everyone. I'm Deborah Burand. I am a professor at NYU Law School, where I teach an international transactions clinic, and I'm also the faculty director of the Grunin Center for Law and Social Entrepreneurship. And as Via just said, this is the second conversation that David and I are having in a webinar format. I should tell you all, I've been really lucky that over this past year, David has agreed to be a thought partner of mine, and we've been having conversations almost once a month for the last year. So it's what you're getting a chance to do today is hear how we've been talking and some of the issues that we've been grappling with as we've started to talk about how one could take impact investing to a next level of contracting, and the extent to which relational contracting, which is something that David has been doing a lot, outside of impact investing, but now inside impact investing too, and what that might mean for us. So let me just do a little scene setting before I bring David into the conversation. As Via said, we're building on an earlier conversation that took place in January about how contracting for impact could benefit from a relational contracting approach. And here's a couple of sort of reasons why I started to think about this. First of all, in the contracts that I've been exposed to, and in some cases drafting myself in impact investing, I've noticed how incomplete they are, often by choice. And that's due to the relatively high transactional cost of trying to create an agreement that is able to anticipate and respond to all the different things that could happen in the life of an impact investment. And so this webinar is looking at how some impact investors and their investees, and this could be debt, equity, or even grants, are turning to a more relational contracting approach that relies on the activation of shared guiding principles to overcome the challenges of this contractual incompleteness. And again, contractual incompleteness that we often deliberately enter into. So there's three major questions that we'll be exploring today, and I'll be drawing on David's expertise in having created relational contracting to lead us through. First, what guiding principles are most relevant to impact investing if you're going to turn to principles to help fulfill and complete the contract relationships that you have? What role do these guiding principles play in filling contractual gaps? And third, how can guiding principles be used to shape decision-making processes among contracting parties that are trying to achieve more than financial returns? So with that, David, welcome. I'm going to hand it over to you to sort of give us a quick recap of what relational contracting is, its key elements, and the benefits of a relational approach to contracting in this way. Thank you for joining us.
Yeah, no, thank you, Deborah, and hi everyone, nice to meet you. And for those of you who participated on the January session, welcome back. Just briefly about me, as it says here, I'm a Swedish lawyer working at a Swedish law firm called Serial Law Firm, and I also have a long experience and expertise in relational contracts. And I'm so lucky, Deborah, that you reached out to me about a year ago, and we could have had these conversations. We will move to these guiding principles shortly. We will start out with just doing a short recap of what is a relational contract. And for those of you who have more interest in this, you should look at the January session. We typically, relational contract is a written contract, legally enforceable and all that, but it has different, maybe a different character. How should I put it? More of a different character, a different aim, maybe. And I typically compare it with a transactional, more commercial transactional contract in 5 dimensions. So, and we have focus, relationship, risk management, social norms, and planning. And the social norms are really the subject for today. So this will be really, really quick now because we want to move on to this social norms or these guiding principles. And in focus, in a more traditional commercial transaction, it's very much the transaction that is in focus. A service being provided, goods sold for a sum of money, and some connected clauses to that transaction or those transactions. Whereas in the relation contract, it's more long term. We know that the deal will change, or the commercial setting will change over time. So we focus much more on the relationship because it's really within the relationship that we create value. So that's one part of it. Of course, all contracts constitute some kind of relationship. In a more commercial transaction or transactional contract, we have an arm's length relationship. Really, we don't really look out for each other's interests. So it's really arm's length. Whereas in the relation contract, we have more of what we call a partnership. We very sort of used and maybe abused term, but there's no better word for it. Where we really, if Deborah and I want to enter into this kind of contract, we will really be obliged to look out for each other's interests long term, etc. And then risk management. The traditional way of risk management in a transaction contract is really, I have enforceable clauses, and if Deborah doesn't do what I tell her, I can take her to court, basically, which typically won't happen, of course, not least in an impact investment. So here we go more to the root causes of the problem in relational contract, a sort of misalignment of interest, misalignment of expectations. We focus much more on that. And so far, these parts have been, we set up a vision, we set up clear goals and objectives, etc. And we also have a strong governance structure here. But as a sort of another component of achieving this, these things with a focus on the relationship, partnership, etc., we have these social norms, which are the guiding principles that we will discuss more today. So I won't go through that anymore, right now. And then as for planning, as you said, Deborah, in an impact investment, at least, you deliberately have to leave some things out. It's impossible to plan for everything, but sort of that is the ambition of transactional contract, to try to cover everything over time. But here we try to create a more of a fair and balanced, flexible framework within the relational contract. But as we have said, now we will focus on this social norms because that is one part of the secret sauces, so to say, of the relational contract. So if we go to the next slide, please. We have an important part of this, of getting to this relational contract, is the process as such. This is not something where I write a draft, I send it to Deborah, and then we start a markup exercise. we really sort of we lay the foundation, we create the relationship first, and then we document that relationship in the contract. So the process as such is almost as important as the contract as such. And there is this 5-step process where we start by laying a foundation to find out whether do we have enough trust and transparency, maybe called cultural compatibility, to create this kind of relationship that we want. In step 2, we co-create a shared vision, a long-term and objectives. What do we want to achieve? What kind of impact do we want to make? Can we divide that impact into separate goals and objectives, or is that maybe one? Discuss those. In the 3rd step that we will discuss more today, that's the guiding principles, which you don't really, I mean, you more discover them as we will discuss here and adopt them. And here you really have laid the foundation for the long-term relationship. And then only then go you into step 4, which is more sort of now we nail the more commercial aspects. So, and who is going to do what and all that. And then step 5 is really sort of setting that crucial governance structure, which we discussed in the previous workshop. I mean, how to stay aligned over time. So that's sort of the quick version of as a repetition mainly of what we spoke about in the first in the January session. But Deborah, anything you want to?
Sure. Yeah, and maybe we could go back a slide. We're not quite to this one yet, but you know, that one of the things that I've been thinking about as we prepared for this webinar is to give a couple more concrete examples of what incompleteness looks like in an impact investing contract, because I think if we can keep that in mind, then we can actually, when we move to the guiding principles, we can start to look at, well, how would those actually help fill these gaps? And so here's 3 ways I've seen incompleteness, and I'm sort of giving them broad buckets. I'm sure everyone here in the chat might have other thoughts that they could mention, but let me take 3. One is incompleteness around the types and sequencing of interventions that these impact investments are trying to achieve. You know, these are hard, complex, what often are called wicked problems that impact investments are trying to address, whether they use the tool of debt, equity, or, as I said, possibly even as a grant. And as a result, if these were easy, they would have been solved long ago. There's not silver bullets. And that means that the interventions that we are trying to achieve and advance in an impact investment, they may not work as well as we had hoped, or not within the timing that we had expected. Or they may work, but they may also create inadvertently some other challenges or harm to the beneficiaries that we didn't foresee. Or, and this came home to roost for me during the pandemic, they're also quite vulnerable to being derailed by exogenous events like a pandemic. And those exogenous events may actually cause our target beneficiaries' needs to shift. So that's one place where I see incompleteness often in our contractual relationships, because we are trying to think through what should we be doing, what actions do we need to take, and how do we respond if we start to see these types of problems. Another bucket where I see incompleteness sometimes, and that goes sort of to your risk management point, David, and this goes to the contractual parties' relative commitment to impact. You know, it'd be great if we all ran into an impact investment, holding hands, fully aligned, and then never had to give another thought about whether we were still aligned throughout our relationship. But that's not how it often works. Parties' expectations and interest shift, sometimes because of things going on outside of the relationship that they are creating. There could be new sheriffs in town, I think is the way you put it. You know, someone who wasn't actually there at the beginning, negotiating this relationship, going through this process that you've set out here, comes in and has a whole different view of how things should work. Or there could be shifts in market conditions or pressures that are shaping the way the parties in the contract, what resources they have, what patience they have, what tolerance they have for risk. All of those things can shift over time. So that might be another bucket where we may have some incompleteness, where our contracts didn't fully anticipate those kind changing goals and expectations. And then a final one is, I was thinking about this one, which is, to the extent that we are putting reporting requirements, and many people do, into their impact investments, it's not unusual for people to realize that these reports that they're getting from their investees, or the investees to realize that the reports that they're being required to provide may be too costly to administer, and relatively not giving the kind of information that is really useful for all the parties to have. We're still learning how reporting requirements can be tailored and work effectively. And they may not only be ineffectual, they may be inappropriate. They may set incentives that we did not intend to set. And they may lead parties to binary decisions, when in fact, the decisions that we have to respond to may be back to the drawing board decisions. We just weren't there. We didn't see what was coming. So those are a couple of ways that I see incompleteness sort of permeating impact investment agreements. I don't know, Dave, if you had any other examples of where you've seen incompleteness coming up in some of the deals you've worked on.
Yes, I mean, I think these are just sort of variants of what you have said. As you know, I mean, typically in impact, there is some kind of theory of change, and you have a hypothesis what will actually work.
Mm-hmm.
And I think in the previous seminar, I spoke about the project that I have been doing and still ongoing with this client, and it's it's a relational contract. It's more of a debt-like, where they're financing a municipality and their project to improve elderly care within that municipality. And of course, I mean, they have great ideas of how to do that, but it can only be in hypothesis exactly how to do that. And they may find, I mean, the outcomes are pretty clear to measure that, but I mean, there can be different ways, and you learn over time. So that's also, I mean, it's sometimes it's hard to know how to create impact. So I would just, say that. And then I realize moving forward here that I may have jumped a bit too quickly to this slide, but I think before we go into these guiding principles and going back to those examples that you have said, of course, I said that the process as such is important, and that is very much about sort of establishing this relationship. And it's hard to manage incompleteness if you don't have a strong relationship. And in traditional contract, where it's more arm's length, as I said. And then things happens that, I mean, it may be the new sheriff or unanticipated events, etc. And then it's really critical to have established that relationship within which you can manage the incompleteness. And you can only do that. That is not doable in a markup exercise, if you know what I mean with that, of course. You have to do it within, of course, the original relationship set up. And then, of course, moving over time, people will change also. I mean, there may be new sheriffs, but they may also be good sheriffs. Not all new sheriffs are bad sheriffs, but still they can have different perspectives and preferences and so on. So that is why this step 5 is also so important, to really think about how to establish this governance structure, and how do we deal with new people coming in. I mean, we have to onboard them in the purpose of this and the spirit of this contract, etc. That is one sort of additional reason why this process is so fundamental, to not only to establish the relationship, but sort of enable the parties to really manage the incompleteness over time.
That makes a lot of sense to me, and I'm glad you stepped back to remind us that the adoption of the guiding principles is one piece of this, but there's other pieces that are so important, and they provide the scaffolding for which these principles then can be applied. So why don't we move to your next slide? And I'd love for you to talk about the guiding principles that you've identified as being very useful in any relational contracting approach. And if you could say a word about these 6 principles and why you landed on these.
Yeah. No, I mean, I thought about this writing a book many years ago about in Swedish. on negotiations really, and I thought about, I have a sociology background, so I'm quite interested in how people behave, etc. Then I thought about, for example, I mean, if you and I would negotiate a contract, and then and you make sort of a proposal, I think we should have it like this in a limitation liability clause or something, and then I say, well, Deborah, that is really unfair, or it's not balanced, etc. Why do you back down? I mean, I may have no leverage, but still you back down. And that's because there are these social norms. Or I may say, well, that may, and they say, I think this is really unfair. Then you say to me, well, I made a concession in the previous clause we discussed. Now I want you to make a concession. Why do I back down? That's because it's reciprocity principle. So we have these norms that are in the negotiation anyhow. And we can really use them to the benefit of the relationship. So the idea here is to agree upon those norms because they're really value creating from the beginning. And originally I came up with 7 norms, but then they were sort of condensed down to 6 norms. And so far, I have not seen any need for additional norms. There have been other suggestions, but I have also always so far been able to relate everyone, but all these suggestions back to this. But I mean, there might be black swans. So I wouldn't say that it will never happen, and we will discuss it today. But these are the principles. So it's the reciprocity principle, which is really sort of this giving and taking. If I invite you to dinner, you will feel obliged to buy me back dinner, or if I make a concession, you will feel obliged to make a concession. Autonomy, that's really a principle not to use power. Power is very detrimental to commercial relationships or any kind of relationship, and we have sort of this psychological, we don't like sort of power, etc. So we should be allowed to make our own independent decisions really. So that's important. Honesty, I think maybe is the most obvious one here, and of course that is about telling truth about facts, but also about our intentions. I mean, you may not really lie, but it may be unclear also what are your intentions? Why are you entering this contract? What's your real sort of intentions behind this impact that you want to create? Something like that. Loyalty is perhaps my favorite principle. That is really this principle to take each other's interests, I mean, and treat them as equally important. That's quite strong, but that is really what loyalty is about in this sense. And we will discuss in a few minutes. I mean, can this be extended to other parties also? So we will discuss that. And then we have equity, which is, I mean, I look upon it as a proportionality norm. Really, we should have right proportions between risks and possible upsides. If we have an outcome-based contract, maybe, I mean, the more risk I take tied to the outcomes, I mean, the higher my potential for gains should be, or things like that. And then we have integrity, which is really sort of to be consistent in applying these other norms throughout the relationship. And also, I mean, if you and I were on the same side, we may be sort of on the investor side, then we should sort of speak with one tongue. We should show in organizational integrity. So these are really, and as you will say, all these are also sort of legal norms. I mean, they exist in the legal system, of course, and it's very much sort of this duty of good faith principle as a general umbrella. I mean, can be said to be those principles. So those are the principles that I have found and that we have worked with, and let's see if there are other principles that will appear maybe in this seminar, but so far that hasn't happened.
Well, let me challenge you a bit there. I like these. I work, as you know, always cross-border, often into cultures that are very different from my own. I am not entirely sure that these principles always translate. I know you say they're revealed, but I do wonder at times if in some cultures, there might be other principles that are viewed as equally important or more important than these. I think of the need, and you may say, well, I think some of these, if you looked at them, could fit that. But I do think of sometimes the need for communal interest to trump everything. That's one place where I've seen it in some cultures. Another thing that I've been thinking about in our space, and this is, you've given a nod to that, is when in an impact investment, the parties say to each other, look, yeah, it's important that we act this way towards each other, but really at the end of the day, are we acting this way towards the target beneficiaries, the people that may not actually even be at the table? And so as I've talked with some of the clients in my clinic, they sometimes have added some additional principles here to reflect the particular type of impact they want to make, the type of beneficiaries whose voices they think need to be considered or needs need to be considered. And sometimes those beneficiaries are easy to identify. Sometimes they're much more abstract. I'm thinking of some of my environmental projects that we're working on. And so you sometimes have proxies that you're working through. I just wonder what your thoughts are about augmenting these, or do you sort of say, no, I think each of these could, maybe you work on expanding the words that are here to meet those types of goals?
No, and I think this is, I mean, we have had this discussion for almost a year, and I really like this. I mean, I think as long as the parties find it valuable and that it really will guide their behavior, that what I think is important, though, is that these are moral norms in the sense that you will feel ashamed if you breach them. So I would have that as a filter. If the parties add another norm, that should be sort of that kind of norm that, oh, this doesn't feel good, because then it will have that behavioral aspect, which is also important part of the gap filling, because that is what will enable you to, even though the contract is incomplete, to do what's good and what's right. So I'm not excluding that. I'm just saying that I think that should be the filter then. But then on the other hand, I think also if we look sort of as third-party beneficiaries, look at autonomy, for example. I mean, you should of course treat them and not sort of agree. You and I agree upon something, and then Svea is a third-party beneficiary. We sort of run her over and use power. I don't know, or we don't consider her interests, which will be in breach of the loyalty norm, etc. We're not honest. We're not really telling the truth, etc. What's supposed to do. So I think that all these principles, I mean, are very much expandable to. I mean, these are also the legislator would use these norms to legislate and sort of treat all its citizens as equals. I mean, sort of the same norms would apply here. So I think that they, to a large extent, will be applicable also in that situation. But I would not rule out, of course, that there may be others. And then also, just as a final thing, I think you have worked in more cultures than I have. I think I get the feeling. I don't know, but I get the feeling. I have worked in quite many cultures, and so far, at least, I have found them to be applicable. I mean, all of them. But again, there may be others.
Mm-hmm. Well, I think this is maybe one of those places where we say these are good conversation starters. This is and then the question for the parties is there anything else they're trying to achieve that would, if they were not met, would give rise to grievance or shame or discomfort? I think that's a really interesting test. So I guess I'd like to move, and just maybe in 3 or 4 minutes, and I apologize for pushing you that fast, but can you give us some examples of how parties have practically used guiding principles to fill some contractual gaps and how that ends up showing up in an agreement?
I mean, I think we have the next slide here. This is a very sort of as part of that process, that is step 3, really. I mean, the part, as I said, we don't invent these principles; they already exist, so to say, but you more discover them. And how we typically do it, we give the parties the examples of wordings. Here I have examples on the screen here of 2 of these principles. And then they can, I mean, I ask this in my facilitating meetings about this, and then ask questions. Okay, so I mean, can you identify this autonomy norm, for example, in your private life, or the honesty in your private life? And then yeah, maybe I said, what would happen if I lied to my friend or my spouse or whatever? That's a too obvious example, but the loyalty principle might be a bit challenging. And then we start to discuss, so what about, what's my experience from my professional life to use these principles? And then we look at the wording here and try to tweak the word. And these are example statements of what you actually put into to the agreement. And here it says, the parties must respect each other's autonomy. No party shall therefore control the other or exert power to force or influence the party to act contrary to the joint vision or to its own partnership interest, or to the partnership's interest. And this is an example. You can, of course, state this in various ways. The important thing here is that you don't leave the core, which is sort of don't exercise power. But then you, of course, can phrase that in different ways. I think we can move to the next slide. We have the loyalty principle here. So the relationship, this is from a real contract. The relationship of the parties is to be characterized by loyalty, which means that the parties, sorry, next slide. Yeah, thank you. Which means that the parties will strive to emphasize the interest of both parties alike. And our interests are equally important. And again, here you can say that, which means that the parties' interests are equally important, or you can say here, emphasize the interests of both parties alike. You keep the core. And this is, I think it's also good. I don't know, maybe this is a lawyer thing, but it's my experience with others as well, that when we start to tweak the wording, we integrate them more into and make them our own, so to say. And we have equity here. As the partnership shall be characterized by equity. What is meant by that? That there should be a fair distribution between effort and compensation, amount of risk carries and compensation for this risk, etc. So this is sort of example. We can move to the next slide as well. I think we have the integrity principle. Okay, so now this was the. Shall I take this now? I don't.
Yeah, go right ahead, because I think so. What you're basically saying is you would put some of those statements you've just shared into the contract, and then this is how you actually then say in the contract that we intend to integrate.
There's a lot of text here on the screen. I will tell you. So first of all, we have the wording. They are sort of, you're contractually obliged to actually follow them. I typically also include a clause saying, well, of course, you have this terminating the contract due to material breach. Then just to emphasize also the importance. And by the way, a material breach of any of the guiding principles is also considered to be a material breach of the contract. But I think this really, the sort of dealing with incompleteness is also very much gap filling principles. So there's a lot of text here, but basically on the left side it says that, well, all contracts are incomplete, as you said, Deborah, maybe deliberately incomplete. And here are some in these scenarios, Roman 1, 2, and 3 here, that the agreement doesn't clearly specify. It can be silent at some points, or it is maybe not silent, but it's hard in Roman 2 to construe what it actually says. And then, of course, we have, we can have contradictions in one document or between documents. And then on the right side, we have there is a general principle saying at the top right here, the interpretation shall be done by applying these guiding principles to find the interpretation that best achieves the shared vision. And that would be one says, well, we shall interpret this as this in the spirit of the contract. But this is a much more granular way of saying that. Really, now we apply these principles to fill in the gaps. And then over the years, when I've been teaching this and others, I have had certain questions. For example, someone asked regarding Roman 2 on the right here, what if we have a conflict between the guiding principles? Mm-hmm. Okay, then we should apply the integrity principle, sort of makes a sort of the most consistent interpretation. And this is basically sort of what you do in law anyway, when you have a principle interpretation. But not everyone are lawyers. And then there in Roman 3, there is an example, for example, what if we have an express right in the contract, but it's this doesn't seem equitable. How do you deal with that? And then you can say, some like to say that, well, then the express rights should always apply. I quite sometimes I say, well, they should always apply unless sort of the deviation from the principle is material, then you should maybe adjust the contract. But there are various ways of doing this. But I think you get the general idea. There is a freedom of contract on how to interpret the contract, so to say. And we use that freedom of contract to really say, this is how we will interpret the contract. And we will fill in the gaps of the incompleteness through these guiding principles and also that shared vision. So this is how we do it in practice.
I have to say, I read this and I immediately start having all sorts of questions. But I think one of the points that you're making is that this is this integration of the principles really needs to be tailored to the agreement. I think one of the things I noticed when I was reading this before our conversation today is this point that they are most useful when we're talking about where the contract is silent or is ambiguous. And I think that interesting point of if there's something expressly in the contract that we defer to that, it sort of says, well, if it's complete, or if there is something here where we've said this, then those rules will apply. But I think it says also to me as a drafter, I better look at all of those rules that I've put into this agreement to see if I can anticipate challenges between the rules I have, like say my force majeure clause, and the guiding principles, because I may decide that some of these boilerplate provisions I put into my agreement are going to, from the get-go, are going to be challenging those guiding principles. And I need to think about whether I need to shift my language in these express rights and obligations.
No, that's an excellent
power.
Point.
Yeah.
No, that is an excellent point. And of course, I mean, especially a common law lawyer would say, no, the express rights and obligations shall apply. But it's also, I mean, sometimes I get a suggestion, can't we use this sort of standard template, standard agreement, and then we just put this guiding principle on top? Wouldn't that work? And then yeah, okay, but that depends really on the content of the standard clauses, right? Because if they're not aligned here, then we will create a sort of a conflict within the document. So I mean, just to your point there, brother, you really need to check at this initial alignment between all the clauses in the contract and the principles.
It also suggests that it's not just the parties that will be reading this. If we ever have to go to enforcement and third-party views, we are speaking to that source of authority.
No doubt. This is a letter. I sometimes say this is a letter to the court, or to the arbitration board, or whoever.
Yeah. So I'd like us, we've got, our time is running short, but I'd like us to try an exercise, David, and we'll do this pretty fast because I want to get to any questions. And if people have questions, start putting them in our chat or our Q&A so we can respond to them. But I'd like to try an example where, and I'm going to invite those who are listening to this webinar to throw their ideas in too. Let's look at 3 examples of how things might go wrong in an impact investment and see what the guiding principles, the 6 that you outlined, might offer in shaping the behaviors of the parties. So if we could go to the next slide. So let's imagine a situation, I think it's often happens, where an impact investee fails to meet their impact reporting requirements. And I didn't give the facts around it. There are many reasons that an impact investee might fail to meet these reporting requirements. And I was trying to sort of imagine what guiding principles would be best suited to shaping the behavior of the investee in this context, and which guiding principles might be really helpful to shape the response of the investor if these reporting requirements are missed. Which ones would you jump to if you were counseling your investee?
That's me, right?
Mm-hmm.
Yeah. So I would go to loyalty. I mean, it's part of your duty to take my interest into consideration. I really need this information, and and to report that in order for me to do what I want, what I intended with this investment. So I would definitely first of all go to loyalty. Then, I mean, I may go to honesty, but that really would depend on why I feel or think that the investee is not, is not reporting. But I think mainly I would go to loyalty in this scenario.
What would you say about the investors' behavior as they respond to this? Which of the guiding principles do you think is most important there?
I mean, how they, what do you mean by responding?
In shaping, so an investor has an investee who has failed to meet their impact reporting requirements, and now they have to respond. What would be the guiding principle that should really
No, I mean, they would have to be careful here. They would have to avoid breaching the autonomy norm by not sort of start to exercise power. Part of that, I mean, they would have to be a reasoned argument for, again, that is why this loyalty principle is. This is why I would say, hey, Deborah, you aren't reporting here. Can you explain to me why? And not say, well, unless you report, I won't give you more money. Instead, please explain to me. I mean, this is really important. Motivate, please. Why do you think it's okay under the loyalty principle not to report to me? So that is part of applying this autonomy norm also. I mean, I respect you and let you make your decisions, but you have a burden of explanation here.
Interesting. So to the next example. This in the next slide. This is where we find out that the impact investee may be doing exactly what we, as the investor, had hoped they would and we planned they would do. But the impact investee is starting to realize that some of these actions are inadvertently damaging, not helping the targeted beneficiaries. So at this point, which principles do you think should be shaping the investee behavior, and which ones do you think are useful for the investor? I have to say, I felt that autonomy was an important one in this one too. For the investor, which is to say, hey, you're closest to the beneficiaries. I will respect your seeing this and observing this and making decisions about what you do. But that sort of is predicated on there being real transparency and honesty by the investee. Yeah.
So you can say, well, also I would say honesty, definitely. I mean, that would be important. They may be, we realize we hurt the beneficiaries, but you must be honest about this and bring it up. And now thinking about loyalty, both out of loyalty to the investor and to the third party beneficiaries, that's a loyal thing to do, right? In this, and then it follows from that. So I would definitely say autonomy, honesty, and loyalty. And of course, we always apply integrity here because we consistently apply these principles and
So let's take our third example. Let's sort of walk ourselves through that. So this is the one I talked about earlier. So you've got an exogenous event like a pandemic or some catastrophic climate event that has gotten in the way of our ability to have this impact that we had hoped to have within the time frame that we had planned for, if ever. And it's this real interesting question that I sometimes have had to talk about with clients, which is we say we have patient capital, but in fact, should we be patient about impact, or should we be impatient about impact? Maybe patient about financial return. So which of these principles do you think would be important to be leaned into by the investee if this is happening? And then what do you think would be shaping investor behaviors?
Yeah, so I think several of them actually. Just we haven't really spoken about reciprocity here, but reciprocity is always about also what has happened historically. We may be in a situation where last year there was another exogenous event, and then we dealt it like that, and then now you reciprocate, for example. So that is one way of looking at it, of course. Again, of course, to be transparent about and that would follow from honesty, but also from autonomy, actually. I mean, to enable you to make autonomous decisions, I need sort of information, and hence I need to be transparent about this. But then I think also, I mean, these things may, the equity norm might come in here, because sort of the risk for us may be unequally shared, actually, depending on the event. And so here is a situation where we might have to adjust the contract, and maybe the timing and other things, in order to keep it fair and balanced. Because otherwise it will be detrimental to the relationship, and definitely to the third parties, so the third party beneficiaries, which of course again would follow from the loyalty. So you see, these are sort of, they are quite similar. These norms, they are different, but they support one another to create sort of a fair solution, so to say.
And I saw Svea has just asked people, or Stephanie has, to put your questions up if you have any. We'll keep looking for them. But while we're doing that, the thing that brought, as you were talking, David, that I think is important in each of these is that while we're focusing on behaviors that may shape the desired impact, they're not divorced from the financial return issues either. And so it's that balancing issue that, again, I think is what makes our impact investments so tricky at times, because as you said, in this context, it may very well be that there are additional now financial cost, real financial cost, and who's going to bear those. And I know you've thought about this in the context of supply contracts, where there has to be sometimes a repricing. When you've had to deal with that in a supply contract, and in this case, if you imagine the supply is impact, that's the good. What principles do you do in supply contracts to really do repricing because of unexpected changes in delivery cost or goods?
I mean, quite often, I mean, it's a number of mechanisms, and it's not only these principles, it's how these principles are expressed in the actual pricing model. Quite often we would have some kind of cost plus model, which really sort of also would take care of a lot of this, etc. We would have what's called a margin matching triggers, where the parties have pre-agreed sort of the lower end or the higher end margin, which a supplier in that case should earn. And if we deviate from that too high or too low, then we trigger sort of a conversation in governance. And I think several of those mechanisms should and could be used also in this case. But you see what I mean? That is sort of an example where you don't only rely on the principles. You need to actually use those principles to be pretty detailed in how you write the contract. So I have, not least based on our conversations, I've started to rethink those force majeure clauses. For example, in large construction contracts. So what if there's there's a standstill in construction? Should this constructor pay all the salaries during the standstill period, or they will go bankrupt? How should we deal with that? And then we would try to find sort of as detailed, because then you have really sort of a financial conflict of interest that can create a lot of tension, of course. So it's good to think about that in advance, not only rely on the principles, because then you will suffer from a self-serving bias. Those were some examples.
No, those are interesting examples, and I'm going to throw another question at you that we started to talk about the last time, and we've sort of slid past it this time. So maybe to bring it into sharper focus. You have some views about the importance of formalizing these relational contracting aspects into the agreement. We saw how you put it into your rules of interpretation. What do you think you gain or lose by formalizing this, as opposed to having these principles agreed but standing outside of the four corners of the contract?
I don't think you lose anything, actually, but but I think I mean, it's not least, it's about, I mean, two things. I mean, people change over time in the relationship. And then you said use the word scaffolding earlier, which is a term I like. And Gillian Hadfield, this another law professor, great law professor, uses this word scaffolding. So that really sort of to support the relationship as people change over time. That is one reason for doing that. Also, I typically say that contracts are often viewed as a sort of as a mechanism to protect yourself from the other party. But I also see it as a mechanism to protect you from yourself, actually. So, I mean, protect you from your own organization, maybe. I mean, or we, you know, as our interests start to deviate, we might shift into short-term thinking, etc. That's also why it's very important to really put this into the contract and realize, hey, I will breach the contract if I don't do this. And also, I mean, if you have the wording here, then as you know, I mean, then it's not really, it can be sort of fluffy. It's sort of vague, but still you will have those questions that you ask. I mean, are all these clauses aligned to these principles? It will force you to think this through much more also and get more clarity around it. So I actually only see benefits. The only sort of not so good things is that many are inexperienced with this. And as you know, we react to new things by thinking it's risky. Actually, the risks go down because you lower friction with this, but sometimes people feel sort of challenged. Oh, this feels unusual. It's just really binding, etc. But that I wouldn't say is really an argument for not having them there. It's just something that I have met, a problem that I have met in the past.
We've just gotten a question in, and I think we're sort of addressing this. We have a attendee who's getting a doctorate at the University of Manchester regarding relational contracts. So my goodness, I would have loved to have had your voice here, not just in the Q&A. And your question is what do you think is the best way to establish a relational governance for contracting? And that's something that is part of when you talk about the processes and what you put into an agreement. Is I've heard you speak to this, David, which is the importance of having a contractual governance provision that sort of, again, leans into these guiding principles that says we will have these regular check-ins, we will normalize ongoing conversations, and as information comes to light, we will respond. And you can react and tell me if I've got this wrong, but we will respond in ways that are, if there's not a provision in the agreement that gives us guidance, we will look to these guiding principles to help us figure out what should happen next. Is that how you would have answered this, or would you?
Yeah, I mean, and I can add to it. Thanks, great question, Dilara. And I mean, it's not enough to just establish social norms. They are part of a system. You should set up. Actually, I have 7 tenets of a governance structure. We don't have the time to set it up here, but you really put up a governance structure with often sort of some lower maybe operational level and some more strategic, maybe have people in a box that the right people speak to one another. You have regular meeting with set agendas, and then also processes for following up on performance. How are we doing, and also how to deal with changes of people, and also escalation procedures. So there are quite a lot of mechanisms there in that part. I think that may be a subject for a separate webinar, but so that's the short version.
Yeah, and I will add to that before we hand this back over to Svea for some closing remarks. I also do wonder if we're moving in this direction and really want relational contracting to take hold, we are going to have to help people feel that there's some predictability in what comes out of these agreements. And that means having predictability out of those third-party enforcers that we may turn to. And I have to say, I'm not entirely convinced at this point that we have decision makers who would understand this, even if we had these things in our contracts. So I think there's probably an educational aspect to training our arbitrators, our judges, our mediators if we have to go to escalating conflicts to get others' views to understanding what really is happening here.
I would, my first question, I will let you over to Sweden, but would be, okay, and to what extent is it predictable in a traditional contract where you don't have this?
Fair point. Absolutely fair point. Okay, Svea, back over to you. Our hour went by so quickly.
It did. Thank you so much for that. This was super interesting. For all the attendees, we have a survey and we're going to send you the link after this, and we'll also drop it in the chat. We really want to hear from you. We can do more of these webinars in the next academic year. So we have one super open-ended question for you to fill out, and then a couple of more specific questions. And you can always email me just directly. We want your feedback. Secondly, we have the CLE form for anyone who wants CLE credit. And finally, register for our conference. We have the image up here on the screen, and we hope to see you there. And with that, we will close, and thank you for giving us this hour of your time and coming here with us. Have a great rest of your day.